Hello everyone, I'm Bob Mudge and I'm with Tammy Irwin today. As you know, the company and our unions have been negotiating over new collective bargaining agreements for the past several weeks to replace the contracts that will expire August 1st.
These negotiations present tough issues about which reasonable people can disagree. But we are committed to continuing productive discussions with union leaders regarding these issues. And we commit to you that we will communicate openly, candidly, and directly about our objectives and proposals during these negotiations. Our credo requires us to do just that, and we will.
It is in that spirit that we want to speak with you today about an important issue. We respect the right each of you has to express your views on the negotiations and to engage in protected conduct, and the right associates have to vote to authorize a strike. As many of you know, strikes are inherently unpredictable events. And if there is a strike, it could be lengthy, as we saw in the recent Fairpoint strike that lasted longer than 4 months. In preparation for this possibility, we want to talk about some events that occurred during the 2011 strike and an agreement with the unions that resulted from these events.
In 2011, we disciplined a number of employees for misconduct during the strike. We did this because we believed then, as we do now, that strike or no strike, there is no reason to tolerate the actions of a small minority of employees who engage in severe misconduct that violates our code of conduct and our credo. There were nearly 100 employees who faced discipline in 2011, and the consequences they faced were significant. Some were suspended for 5, 10, 30, or 45 days without pay. Others were terminated. You may have heard that almost all of those employees who were terminated were reinstated by agreement with the unions when new labor contracts were signed. What you may not know is that the company and the unions agreed that those who were permitted to return would not receive back pay for the 15-month period they were out of work.
You also may not know that when new labor contracts were signed in 2012, the company reached an agreement with the unions that addressed potential misconduct in the future. The company and the unions reaffirmed that employees have the right to engage in lawful strikes and activities protected under the National Labor Relations Act. The parties also agreed that in the event of a future work stoppage or strike, any of the following acts would constitute just cause for discharge. The use of racial or sexual slurs or other hate speech that vilifies a person or a group on the basis of color, disability, ethnicity, gender, sexual orientation, nationality, race, religion, or other legally protected status. Threats of physical or sexual assault directed at individuals or their family members. Physical assault with the potential for causing bodily injury, but not including incidental bodily contact. Significant damage to company or personal property, and reckless driving, endangering others that impedes or interferes with the operation of a company vehicle. Lawful mobile picketing, including following company vehicles during a strike, is not a basis for discipline. So as a result of what happened that summer, the company and the unions agreed that these offenses would be just cause for termination. When we discuss these issues, we do so knowing that the vast majority of our employees would never consider acting in such a manner. Most of you share our view that as much as we may disagree on some of the issues that might lead to a strike, that all strikes eventually end. And we all share a common goal of the ultimate success of Verizon.
We hope that we can maintain a focus on the fact that the most important group in our future is our customers. They will judge our behavior by standards of common decency. We assure you that management will not lose sight of that perspective, and we hope you do the same as you exercise your rights. Thank you.